the big ticket item in these matters is the Family Law Act 1975. It's Commonwealth legislation, so the law as it relates to parenting matters is consistent federally. This does not extend to the consequent welfare jurisdiction that's referenced in various state and territory legislation, but we're not going to go into that today. I'm just letting you know that so you can add it to your knowledge bank. Part 7 of the Family Law Act sets out the law in relation to parenting matters. It is full of a multitude of interesting sections. If you've not looked into section 60A to 70Q of the Family Law Act, you should go and do it. It's great. It doesn't sound like a lot of legislation, but keep in mind our legislators keep sliding in extra subsections just to keep us motivated. So around the section 65Ds and Zs, the 69Zs and the 70Ns, it all gets a bit messy. That's a bit nerdy, but go and have a look. The sections that you need to pay particular attention to in parenting matters, and especially with reference to schooling issues, are section 60B, which outlines the objects and principles underlying part 7 of the Family Law Act, section 60CA, which provides that in deciding whether to make a particular parenting order, the court must have regard to the best interests of the child as the paramount consideration. Section 60CC, that outlines the primary and additional considerations the court is to take into account in determining what's in the children's best interests. And those primary considerations are the benefit of a child having a meaningful relationship with each of the child's parents, and the need to protect a child from physical or psychological harm and from being subjected to or exposed to abuse, neglect, and family violence. It is well settled now and part of the legislation that the court is required to give greater weight to that protective consideration out of the 2 primary considerations over the other one. Section 61DA is also important. It provides that when making a parenting order, the court must apply a presumption that it's in the best interests of the child for the child's parents to have equal shared parental responsibility. It's a big concept and a really important one. This presumption does not apply in some circumstances as set out in this section, and in particular where there are grounds to believe that a parent or a person with whom a parent lives has engaged in abuse of the child or family violence, and that's in section 61DA2. The presumption may also be rebutted if the court is satisfied that an order for equal shared parental responsibility would not be in the child's best interests, and that's in section 61DA4. But coming back to the topic of today's conversation, and this is where it's going to start to get a little bit heavy. I like to go firstly, or at least, we're going to today, to a 2013 family court case. It's the case of Bills and Brueggelmann. I don't know if I've said that correctly, but that's what I say. And in that case, Justin Austin summarised the principles governing the resolution of schooling disputes with reference to the very helpfully named 2000 family court case, Re G Children's Issues. Children's Schooling. And also the 2011 family court case of Eden and Eden Proust. Again, I don't know if I've said that correctly, but we're going to go with that. What Justice Austin says at paragraph 81 of Bills and Brueggelmann is that schooling disputes are not resolved by application of a blanket presumption or preference for views held by the residential parent. And that kind of echoes what the full court said in Re G. The court is required to apply the objects and principles of Part 7 of the Act and to consider the statutory criteria informing conclusions about the child's best interests. Now, this case is an interesting one. Justin Austin explains the considerations relating to the party's 5-year-old child in the context of a determination about what school the child should attend. There were a whole bunch of other issues as well, but that's what I'm focused on today. The child had already been enrolled in a school unilaterally by the mother. It was a Magellan matter, although some of those matters appeared to have fallen away at trial. And he ultimately ordered that the child's enrolment change from a religious school to a public school in close proximity to the mother's residence at the beginning of the following academic year, and for the child to attend scripture classes at the public school. So the court has some pretty, broad powers to redefine how people are living their lives and managing the education of their children. The other matters summarised by Justice Austin about the approach adopted by the full court in Re-G schooling issues are, and I'm just going to list them, that the process of evaluation should not entail an assessment of the relative merits of schools preferred by the parties, at least in circumstances where the competing schools are prima facie satisfactory. And there was all that NAPLAN evidence that came out, and people thought maybe this would be helpful to put in applications regarding schools, but obviously, evaluating it, or an evaluation of it by a court, is a pretty, limited, it's of limited forensic use in terms of determining it. Secondly, ordinarily, it's in the child's best interest to attend a school that is close to his or her residence. And I mean, that seems super practical. Thirdly, it's proper to consider evidence as to the greater effect of the decision upon the resident parent rather than the non-resident parent, but that doesn't mean the convenience of the non-resident parent is ignored. So look, if a kid is spending more time in one parent's home than the other, again, that seems fairly sensible. While the views of the child are relevant to the inquiry, as section 60cc3a sets out, those views are usually not determinative. And that's a really interesting point from my view, as, it seems to kind of have some hope of mitigating, triangulating kids in the dispute and dissuading parents from trying to get those kids to champion the parents' agenda about things. Whether or not, it is useful in that regard, I don't know, but it's nice to hope so. And lastly, he noted that the conflict in the authority, he noted that there's conflict in the authorities about whether any prior agreement between parties concerning a child's schooling is influential, and that there's also a conflict in the authorities, or a difference of opinion about the need to refer specifically to the factors enumerated in section 60cc or to go through them, or whether it's permissible in making these decisions to simply analyse the evidence discursively with those factors in mind. So that was a really helpful summary in that case about the kinds of things that need to be considered. Now, one of the big takeaways from schooling decisions cases where a child goes to school is that they are highly discretionary matters. And one of the cases that I really like about, around this topic is one that involves like an Xbox controversy. It's not the schooling part of it, but it's how I remember the case. And we're going to talk about it a bit later, but it's a case of, it's a 2007 family court case of Kirkland and Granger. And it really does delight me, this case, because, some of the things that Justice Cronin says in it are pretty pertinent around people being sensible and reaching agreements about things. The experience was probably not so great for the litigating parents or the 15 and 12-year-old subject children, but it is kind of an exciting one to read. So what Justin Cronin says is, at paragraph 62, and I'll just read it, that in my view, the starting premise is that a court should only interfere with parental responsibility where it is important for the child's best interests that it do so. And this is important when we come back to the Xbox issue later, but we'll just park it for now. He references Justice Carmody in a case of W&G number 2, which is a 2005 case, and says from that judgment, judicial interference in the performance of an aspect of parental responsibility shall occur only as a last resort, or where the welfare of the child will be clearly advanced by the order being made. Justice Carmody went on to make a rather profound statement that applies in this case. He said, "It is important to remember, however, that best interests are values, not facts. They involve a discretionary judgment in respect of which judges can come to opposite but reasonable conclusions on the same body of evidence. They necessarily involve predictions and assumptions about the future which are not susceptible to scientific demonstration of conclusive proof." It's heavy stuff. Predications and even intuition and guesswork can all play a part in the making of a parenting order. There is no single or simple answer, and there is always a real chance, despite best evidence and the search of the best interest solution, of getting it wrong. Now, I think that's a great summary of family law in general. And when I read that, I kind of feel like family law is the practice of the dark arts, but I kind of digress, but I think that's a really interesting kind of reflection by a judicial officer on how challenging some of these cases can be and how discretionary all of this stuff is. So just to wrap up this part of the talk, the choice of school is one of the categories of major issues which parents who have equal shared parental responsibility should exercise together. In circumstances such as this, when parents are unable to agree, the court can be asked to intervene in these decisions, and the court can make some fairly robust decisions about what should happen in people's lives, which, is pretty extraordinary. Absent an order for sole parental responsibility, a court is likely to consider this to be a matter that should be considered jointly by parents. So if you're launching into court and haven't had the conversation yet, that's a really bad move, and the court's probably going to be quite critical about it. And we should all look back to the fundamentals in Re-G children's schooling because it's the case that says it all, where the full court considered the proper approach to schooling issues. And in particular, in that case, the full court found that the trial judge had erred in giving preference to the proposal of the parent with whom the child primarily lived, and that's how they went through some of the factors that the court needs to consider. And I'll just do one more summary, which we kind of went through in the other case, but just to set out what Re-G says, it says you have to consider the competing proposals of the parties, the views of the child when appropriate, any prior agreement in selection of schooling, any change to existing arrangements, any anxiety the child may experience as a result of changing peer groups, the views of the parties about the effect of the change on the child, travel time to school, and costs of education. And, the full court said this list is not exhaustive and the relevant factors will vary in accordance with the individual circumstances of the factual matrix of the case they're dealing with. So it's all very practical stuff, and obviously stuff that needs to go in your evidence if you're litigating a case about schooling issues. If you don't address these things in your affidavit material, obviously your case is likely to be deficient. So heaps of other things flow from this line of jurisprudence, such as things like the management of extracurricular activities as well, and information sharing and so forth. I don't really have the time to go into that today, but I will say there is a really good case to read about extracurricular activities, and that's a 2017 family court case of Gatting and Snell and others. And, in that case, again, there's a really helpful summary where the court says, look, this is the stuff we need to avoid by putting kids into too many extracurriculars. So what flows from that is if it's not going to be a problem, it's okay. But, if these things are enlivened, watch out, we might not make the order. And at paragraph 82, what that case says is that it's important for I'm just going to read it. It's important for the sake of the children that neither parent burdens the child with activities that cause difficulty in the other parent's household. If that were to occur, one parent ignoring the impact of a decision on the other's household, it could give rise to risks that, one, a child may become overburdened with activities. Two, a child may be disadvantaged because a parent may not be able to physically carry out that activity. Three, a child may see the inability, or for that matter, the reluctance of a parent to carry out an activity as being unreasonable or unfair, thereby prejudicing the parent-child relationship. Four, that confusion about events, equipment, and parent involvement can cause embarrassment and loss of self-esteem for the child. And five, any cooperation and goodwill between parents is strained. So this is all good stuff. And in that matter, a whole bunch of restraints pursuant to Section 68B of the Family Law Act were made, precluding the involvement of the kids in extracurricular activities. So just to add on to things, you probably can give it a read if you're interested. So the second part of this discussion is about who pays for schooling arrangements post-separation, and continued financial contributions towards school fees and extracurricular activities is often a super controversial subject between separated parents. The Child Support Assessment Act 1989 has a principal object to ensure that children receive a proper level of child support from their parents. And the particular objects of that act, so there's a principal object and particular objects, include that the level of financial support is provided in accordance with the parent's capacity to provide financial support, that parents with a like capacity should provide like amounts. Two, that the level of child support should be determined in accordance with the costs of the children. Next, that carers should be able to have the amount of financial support assessed without the need for court proceedings. Pretty sensible, because it's almost counterproductive to have to go and spend money to fight about these issues. And that children sharing changes in the standard of living in both of their parents' homes, whether or not they live with either of them, and also that Australia meets its obligations under international agreements, but that's less interesting. The Child Support Assessment Act also states that a parent has a primary duty to maintain their child, and it sets some things out about that which you should just go and read. But moving on, so basically periodic child support payments, which are referenced to these principal and particular objects, is based on a formula that takes into account certain factors like income and the allocation of time that children spend between parents. So it's pretty easy to determine post-separation what kind of periodic child support is required to be paid. But non-periodic expenses, such as private school fees, do not attract the formula. And this is where disputes can arise, and surprise, surprise, it's also a very discretionary issue and turns on the particulars of each set of circumstances. So a parent or a non-parent carer can apply for a change of assessment in special circumstances if the costs of maintaining a child are significantly affected by high costs of caring for, educating, or training the child in the way both parents intended. It's a pretty wordy kind of, basis to be able to change the assessment, but that's what you've got to demonstrate. The relevant sections of the Child Support Assessment Act are Section 98B1, Section 98C, Section 98S, Section 117 2B2, and Section 117.4 to Section 117.9. The relevant sections of the Child Support Registration and Collection Act, which you've obviously got to deal with both, are Section 71C and Section 71D. The phrase special circumstances of the case is not defined in the child support legislation, but the Family Court has defined that, and they held in the case of Gieselman, which was a 1992 case, again, I probably said that wrong, that it is intended to emphasise that the facts of the case must establish something which is special or out of the ordinary. So it's also interesting to note that the fact that a payer can afford to pay fees or is wealthy is in itself not a reason for the imposition of a liability to contribute to school fees. And that's found in the full court authority of Me and Ferguson, which is a 1986 case. So, just going, look, they can pay it isn't enough. You've got to demonstrate something more. Also, in deciding whether or not the reason's established, a registrar, in determining it through the Child Support Agency first, will also consider the type of education intended by both parents for the child rather than the particular school intended by the parents. And that's found in a case of Wild and Ballard from 1997, and is quite important because, again, saying, look, we said the kids would go to school X, that's not the end of it. So it's more about the type of schooling that was intended. Ultimately, if a reason is established, a registrar, because these things are dealt with administratively first, again, coming back to this whole, avoiding people having to go to court at first blush, the registrar must consider whether it would be just and equitable to the child, the payer and payee, and otherwise proper to make a particular declaration, determination, and that's found in section 98C 1B2. And if a party disagrees with the ruling made by the Child Support Agency, there are then review processes in place. It's fairly stringent, the basis upon which people can review these matters to the court, and generally it's only after the avenues through the Child Support Agency have been exhausted. So my takeaway from this part of the talk is that people should discuss these decisions and how these costs are going to be managed at separation. They should absolutely, if they haven't discussed it then, be talking about it when they're determining parenting arrangements or property settlement arrangements, because again, that's another good kind of point to explore what the agreements are going to be about this stuff. And sometimes it's challenging because people think, oh, look, I don't want to bring up the child support stuff because it might derail the discussions we're having about our parenting issues. But the problem is, if it is going to derail, some kind of goodwill or become a dispute, better then than having to do go through the motions of working through these issues twice. So that's my takeaway. The other thing is parties can enter into child support agreements about school fees to ensure some certainty. We assist clients in the preparation of those documents. The thing about that is, though, they do require consent and agreement. That's why they're called child support agreements. And I think we have some information about that on our website, so you can go and have a look there. Last point, and point 3 of this discussion, is about sorting some of this stuff out. So there are a few things to consider. Firstly, and this is really important, it's not really legal, but it's just about being good people. Everyone should always remember that it's not a school's responsibility to be the facilitator of a dispute in relation to this stuff. The school is not there to interpret orders. They're not there to act as the policeman between warring parents around this stuff, or the judge. And so, schools should be left out of it. And the other reason why that's really important is if you go to court about a school decision later on, what you might find is that people will subpoena the school records, which are, probably relevant to the proceedings, and the school will probably have written a whole bunch of bad stuff about you. So just leave them out about it and don't embroil them in the dispute. Secondly, pursuant to Section 60I of the Family Law Act, the court will expect you to have tried to sort these things out first through family dispute resolution. And most things settle there. And because I love stats, the stats say that only 3% of separated parents use courts as their main pathway to making parenting arrangements. And that's quite cheerful to hear, frankly. These are often predominantly family arrangements that are affected by some really challenging stuff like family violence, child safety concerns and other complex issues. So, otherwise you've got to have a go at trying to get through these issues and working them out. Now, coming back to the case that I like, Kirkland and Granger, and what Justice Cronin said in that case, this kind of wraps up all of these issues, for me at least. And so I just want to end this talk with the outcome of that litigation, and basically it's there to kind of motivate you to first seek to resolve these matters with lawyers where necessary before litigating them. And so, I'm going to set out some things that happened in that case that might dissuade you from litigating these issues. So Justice Cronin was asked to determine 4 particular issues in this case, and in doing so, he made reference to subplots, which I loved. And one issue was about whether or not the 15 and 12-year-old subject children should move from their school to a local Catholic school, and he sorts that out, no problems. And there are 2 other issues I'm not going to go into. But the other issue that he was asked to determine, and I'm just going to read this because I like his turn of phrase and it's just cold. But he describes the issue as whether a computer game system, this is his words, but it's kind of how I talk to because I'm not techno, known as Xbox, of which there are 2 in the husband's household used by the children C and L, should be divided up so that each house has one such machine. Within this dispute, there is a subplot as well, in that the father wants an order made that he acquire a new Xbox and provide it to the mother. Another potential subplot is whether I should consider allowing the children to carry the Xbox equipment backwards and forwards between the homes and order the parents to facilitate that. Again, judges have all these powers. So this is pretty grim stuff. And, it's grim that this judge had to get into the weeds over it. But, and I like it because I can only imagine what kind of affidavit material must have been filed, advancing each party's position about this issue. And, what they would even have been saying to their friends and family, like, what are you fighting about still? Oh, the important Xbox logistics issues. Like, it's just mind-blowing. But anyway, Cronin got through this stuff. And in my mind, at the end of this litigation, everyone was sitting there waiting for his judgment, sitting at the bar table with bated breath, and the resolution of this Xbox issue, which probably had been on foot for a long time. I mean, family law proceedings can take 2 years to resolve, and people there had spent money, time, energy, and dignity fighting this issue. And then Justice Cronin says at paragraph 75, I'm just going to read it. Turning then to the respective proposals and their relevance to any parenting issue associated with the best interests of the children, I am mindful of the provisions of section 65D1 about what is proper. Apart from considering a situation where these children share the items acquired by themselves or their parents, I cannot see how it is proper for the court to become embroiled in a dispute which should be sorted out between the parents and the children. If the children wish to have their particular Xbox at the mother's home and the father will not permit it or them to travel, I suspect the respect of the children for their parents will ultimately be diminished. Like, it's a burn. Accordingly, I propose to make no order about the Xboxes. And you just think, drop the mic, like no one gets an answer. And I can only imagine that people must have been outraged by this. And I do worry about, what C and L then did for their entertainment. But I think this is good. And I think it's a timely reminder that people should not, litigate the small things unless you have to, because, what's a court going to do about those issues as well? What you should do instead is seek some advice, obviously from us, that's cool, and hopefully participate in some dispute resolution processes if you can, to try and mitigate and minimise the exposure of harm of these kinds of things on your family. So that's all from me. Have a good day. I hope that was helpful. Thanks, bye.